Welcome to Academy of Civil Services, UPSC, APSC, online coaching, Indian Polity, Chapter 6. Today's discussion is on citizenship of India. Citizenship, after discussing about the Union and its territories, which is discussed in Part 1 of the Indian Constitution from Article 1 to 4, now we are moving to the Part 2 of the Indian Constitution from Article 5 to 11. Then citizenship of India is discussed in Part 2 of the Indian Constitution. Articles are Articles 5 to 11 discusses about the citizenship of India. Now, before going into the deep analysis of the citizenship of the country, we can check what are the articles discussing. As all of we know, we got the independence in 1947, but unfortunately, we got the independence not for an undivided India. We got the citizenship for two separate countries, India and Pakistan. Then the citizenship became very complex. There were migrations. Somebody migrated from Pakistan to India and somebody migrated from India to Pakistan. Then the Constitution of India analyzed in detail how the citizenship should be given, what should be the criteria for giving the citizenship for the people who are residing in India or the people who migrated from Pakistan to India. Different complex issues were there in deciding the citizenship or finalizing the citizenship of the country. Then from Article 5 to 11, it describes different categories of the people, how they will get the citizenship of the country. We can go into the articles one by one. First one is Article 5. Article 5 discusses about the citizenship at the commencement of the Constitution. And while the Constitution commenced, citizenship at the beginning or at the commencement of the Constitution, different types of citizenship or citizenship at the commencement means that when we commenced the Constitution of India, the people who were in India, who were residing in India and who were considered to be Indian, they got the citizenship automatically. That is Article 5. All the people who are in India and are the people of India at the time of the commencement of the Constitution of India would be considered as the citizens of India. Next is Article 6. After Article 5, Article 6 discusses about some other category of the citizens. Article 6 mentions about the right of the citizenship for certain migrants from Pakistan. Somebody migrated from Pakistan to India. They did not want to stay in Pakistan. They were against the idea of the Pakistan or separating India into Pakistan in the name of the religion. Then those people who were inside the territory given to Pakistan and opposed the idea of Pakistan and supported India, they migrated to India. Then they should be given the citizenship of India. Then Article 6 discusses about the rights of the citizenship for the persons who have migrated into India from Pakistan. Then citizenship for migrants to India from Pakistan after the independence. Migrants to India from Pakistan is discussed in the Article 6 of the Indian Constitution. Now, some other people were there who were inside India and Indian territory and they wanted to migrate into Pakistan. They went to Pakistan and Pakistan had different provisions for giving the citizenship for such people. But after migrating to Pakistan, they did not find it comfortable for them. And after going to Pakistan and experiencing the life in the Pakistan, they wanted to come back again to India. And India accepted them also because we got independence as a secular democratic country, not as a theocratic country based on any religion. Then even the people who migrated initially from India to Pakistan and came back to India they were also considered for a citizenship subject to some kind of registrations after reaching to India and approval from the Indian authorities. Then Article 7. After Article 6, Article 7 discusses about the citizenship for the people who migrated from India to Pakistan and returned to India with the will of staying India as the citizens of India. Then 7 discusses about right of citizenship for certain migrants to Pakistan. Then citizenship for migrants to Pakistan, the people who migrated from India to Pakistan, they have also certain provision to get the citizenship of India again. Those who returned to India after migration to Pakistan with the permission from Indian authority can get the citizenship as per the Article 7 of the Indian Constitution. It recognizes the citizenship for the Indian people who migrated initially into Pakistan when they felt the experience in Pakistan was not comfortable for them. They wanted to return to India and return to India after getting permission from the Indian authorities. They also can get the citizenship of India under Article 7. And next is that Article 8. During the independence of India, we told that Article 5 gives the citizenship for the people who were in India during the commencement of the Constitution. Article 6 gives to the citizenship for the people who migrated into India from Pakistan. And Article 7 gives the citizenship for the people who migrated to Pakistan initially and returned back to India with the permission from the Indian authorities. They will also get the citizenship. And next is age. Age. When we got the independence, some people were they are Indian origin people, or the people of India, and their fathers were the people of India, and sometimes the father and mother were the people of India, but they migrated into some other foreign country other than Pakistan, and the children were born there and brought up there. These people are called as the person of Indian origin. Their origin is in India. And other people may be also like this. The people of India during the British time, they migrated to any third foreign country other than Pakistan. I am aiming the third foreign country means that other than India and Pakistan. They were settled in any foreign country outside India during the British time. Now, when we got the independence, they want to be the citizens of India. They were also given the citizenship under Article 8. Article 8 discusses about the citizenship for persons of Indian origin residing outside India. The condition for them to get the citizenship is that they have to register with the Indian embassy in that particular country, or the High Commission of India, or any Indian consular in that particular country. They have to register with them, then they will also get the citizenship. Then Article 8 discusses about the citizenship for person of Indian origin. In short, they are called as PIO. Citizenship for PIO residing in any foreign country. For any foreign country, they can also get the citizenship. The only condition, they have to register for the citizenship, fill up the form for citizenship in the Indian embassy or Indian council in their concerned country where they are living. Then Article 8 discusses about the citizenship for the PIOs, or the persons of Indian origin in a foreign country. Next is Article 9. Article 9 discusses about how a person will lose the citizenship of India. Loss of the citizenship, that is discussed in the Article 9 of the Indian Constitution, how a person will lose the citizenship of India. Obviously, if a person voluntarily takes the citizenship of another country, he will automatically lose the complete citizenship of India. Now there are provisions to keep some OCI card, Overseas Citizen of India card is there, but they will not have a complete citizenship passport of an Indian person. Then Article 9 discusses about that if a person voluntarily acquires the citizenship of any foreign country, and he will automatically or she will automatically lose the citizenship of India. That is discussed under Article 9 of the Indian Constitution. Now we can look what is Article 10 and 11. Article 10. Article 10 talks about the continuance of the citizenship. How long a person. Now under Article 5 we have given citizenship to certain category who were inside India at the commencement of the Constitution. Under Article 6 we have given citizenship to the persons who migrated from Pakistan to India. Under Article 7 we have again given citizenship to the people who migrated from India to Pakistan initially and made a reverse migration into India back. And under Article 9, under Article 8, we discuss that the people who are persons of Indian origin residing in any foreign country can get the citizenship if they register with the concerned embassy or council of India in that particular country. And under Article 10, under Article 9, we discuss that if a person voluntarily acquires the citizenship of any other country, he will lose the citizenship of India. Now Article 10 talks about how long a person will get the citizenship. Is there any validity? In 1950, we are giving the citizenship. Then is there any validity whether the citizenship is for 10 years, 20 years, 30 years? Then Article 10 talks about that continuance of the citizenship of the people who got it now till the end of their life. This is a lifetime validity. There is a lifetime validity for the citizenship. In another way, we can summarize it as continuance. If you are borrowing the word used in the Constitution of India, Article 10 discusses about continuance of the citizenship. And once a person gets the citizenship, it will continue for the lifetime unless and until he acquires the citizenship of any other country, then he will lose it. And some other provisions are also there. Somebody declares that I am against India, or somebody declares that I will not accept the Constitution of India, then also he will lose. But it will not be automatic. Government will take the citizenship back. Otherwise, if there is no extraordinary exceptional situation, in the normal cases, the citizenship of a person will continue for the lifetime. Then all the people who are mentioned above in Article 5, 6, 7, 8, they will continue to be the citizens of India until the end of their natural life if there is no extraordinary circumstance or some exceptional cases which is mentioned in some acts of parliament or in the Constitution of India. Next is the last article in this chapter, that is Article 11 of the Constitution. Article 11 of the Constitution, what it talks about the citizenship. Now, in these articles we have discussed how a person can get the citizenship, how a person can lose the citizenship. Can get the citizenship just after the independence. But now after the independence we have given now the new citizenship. What are the procedure for giving a new citizenship of India? Whether an American person can get the Indian citizenship, or a newborn baby, how he will get the citizenship of India, and a person who is born to an Indian outside India, how they will get the citizenship of India. That procedure is discussed in the Article 11, but Article 11 does not explain how a person can acquire the citizenship of India. It tells that Parliament can regulate the rights of the citizenship in India. Article 11 tells that Parliament of India or Parliament has the right to regulate the citizenship in India. Has the right to regulate citizenship. That means, and any other thing which is not mentioned in the previous articles, the Parliament of India can take a decision how to control the citizenship, how to give the citizenship to a new applicant, how to give the citizenship to a newborn baby, how to give the citizenship to a person who is born outside India for Indian parents. All these issues will be decided by the parliament, can regulate the parliament has the right to regulate citizenship of India, and any other issue which is not discussed in these articles will be decided by the Parliament of India, that is Article 11. Now we are moving in detail to different methods of acquiring the citizenship of India. Now, as per the provisions of Article 11, because Article 11 tells that the Parliament of India can make an act, or the Parliament of India has the authority to regulate the citizenship in India. Then using this provision, using this power of the Parliament, Parliament of India passed Citizenship Act 1955. Citizenship Act 1955, it talks about how to acquire the citizenship of India. What are the methods of acquiring, or the ways to acquire the citizenship, to get the new citizenship of India? In what ways, what methods a person can get the citizenship of India? Then Citizenship Act 1955 talks about 5 methods of acquiring the citizenship of India. It gives there are 5 methods through which a person can get the citizenship of India. First one is by birth. A person can get the citizenship of India. Now a new person can get the citizenship of India by birth. Second one, by descent. I will explain each and every one in detail. Second one is by descent. And third one is by registration. And fourth is by naturalization, and the fourth is by naturalization, and the last and fifth is by incorporation of a territory. By incorporation of a territory, by adding a new territory into India. These are the 5 methods of getting the citizenship of India under our Citizenship Act 1955. We can go in detail into all these 5 and what is the explanation of all these 5. The first one is that the first method of getting the citizenship according to the Citizenship Act 1955 is by birth. We can check how a person can get the citizenship by birth as per the Citizenship Act 1955. And according to the condition is that by birth, all the people who are born in India between 26 January 1950 up to 1st July 1985. The date is very important. Starting from 26 January 1950, that is the Republic Day, up to 1st July 1987, the condition was that everybody who is born in India, he can be a citizen of India, irrespective of the nationality of the parents. For example, I can tell you, if a US couple, US husband and wife, they came to India, when they visited India for a tourism, the wife was pregnant and she has given delivery to a baby boy or a baby girl in India, then that boy or girl, that child has the opportunity to get the citizenship. Up to 1st July 1987, there was a chance for such a child to claim the citizenship of India according to the Indian Act. But it created many controversy, whether everybody who is born in India, somebody may come for a medical treatment to India from Pakistan or Bangladesh during the time of their pregnancy, and they give the birth to the child in a hospital in Delhi or Hyderabad or Chennai, whether they can get the citizenship, is it reasonable or not? And we made an amendment into the Citizenship Act 1955 in 1986. That amendment came into effect on 1st July 1987. When that amendment came into effect on 1st July 1987, the law got changed, and after that, everyone who are born in India after 1st July 1987 will get the citizenship if either of the parents is an Indian. Either father or mother is an Indian, only then they will get the citizenship. Then by birth, the condition was that from 26 January 1950 up to 1st July 1987, any child born in India can get the citizenship of India irrespective of the nationality of the parents. But after 1st July 1987, anybody who is born in India after 1st July 1987 can get the citizenship only if either of the parents, either father or mother, is an Indian. One more condition we added. After 3rd December 2004, we changed the condition. After 3rd December 2004, we added one more condition that a person, the babies born to the illegal migrants, either father or mother is an illegal migrant to India, came illegally without a valid passport, without the valid documents, by the crossing the border from Bangladesh or any other country. If somebody came to India and got married with an Indian, and if they had a baby, that baby will not get the citizenship after 3rd December 2004. In 2004, we added that clause also into the Citizenship Act 1955. Then the conditions are there for the birth in India from 26 January 1950 till 1st July 1987, all the children who are born inside the geographic territory of India were eligible to get the citizenship irrespective of the nationality of the parents. Then all the children who are born in India after 1st July 1987 can get the citizenship only if either of the parents is an Indian. Then one more condition, all the babies who are born in India after 3rd December 2004 to an illegal migrant to India, either father or mother is an illegal migrant from any foreign country without valid documents and got married to an Indian father, Indian man or woman, their babies will not get the citizenship of India. That was to demotivate the illegal migration. Another one, to discourage the Indian citizens from getting married to an illegal migrant. For that purpose, we brought that act. That is the conditions for getting the citizenship by birth. The next way of acquiring the Indian citizenship according to Citizenship Act 1955 is by descent. Descent means that if anybody is born outside India, how they will get the Indian citizenship. A baby, first thing is that it has also 3 layers of the terms and conditions. First one, any baby who is born outside India between 26 January 1950 and 10th December 1992. If any baby is born outside India between 26 January 1950 and 10th December 1992, he or she will get the citizenship of India if the father is an Indian. It is a controversial thing. If the father is an Indian, then they will get citizenship. But there is a controversy. Imagine that an Indian woman, she got married with a Russian man. Then the father is a Russian, mother is a woman. Then this baby was not supposed to get the citizenship of India if he is born outside India. In Russia, he was born. The father was a Russian and the mother was an Indian. She migrated to Russia and got married with a Russian citizen. If they had a baby and if the baby is born between 26 January 1950 and 10th December 1992, he will not get the citizenship, or that baby will not get the citizenship. But if the father is an Indian, he migrated into Russia and got married with a Russian woman, then they had a baby, that baby will get the citizenship. Then any baby, any child born outside India will get the citizenship of India between 26 January 1950 and 10th December 1992 only if the father is an Indian. Then women, they started protesting that we have also the equal right of the baby. Even if the mother is an Indian, why this discrimination on the basis of the gender? And mother has more role in the birth of a baby, then she should be given prominence and in the recognition of the baby. Then on 10th December 1992, we changed the law. Then all the children born after 10th December 1992 outside India, any child born outside India after 10th December 1992 will get the citizenship of India if either of the parents is an Indian. Either mother is an Indian or the father is an Indian. If both mother and father are Indian, then obviously the child will get the Indian citizenship. But even if either mother or father is an Indian, the person can get, or the child can get, the Indian citizenship after 10th December. After we amended the law on 10th December, the child will get the citizenship of India. And next, one more condition was there. And before that, there was no time period, because if the child is born outside India, it needs to be registered with the Indian Embassy or the Indian Council. Earlier, there was no time limit when to register. Somebody were registering after 2 years or 3 years. When the child is 3 years old, when they want to come back to India, they have to get a passport and visa. For that purpose, they were registering. But in 2004, we added one more clause that if a child is born for an Indian parents or an Indian woman or an Indian daughter, Indian husband, or both an Indian parents are the Indians, then they have to register with the concerned office or the embassy within 1 year. Then after 2004, the birth of a baby or a child outside India has to be registered within 1 year. Then registration within 1 year was added by 2004. Then by descent, 3 categories are there. 3 conditions are there for the citizenship. From 26 January 1950 up to 10 December 1992, if a baby is born outside India, he or she will get the citizenship if the father is an Indian. Then after 10th December 1992, any child born outside India will get the citizenship of India if either father or mother is an Indian. One more condition, all the children born after 2004, their birth has to be registered with the concerned Indian embassy within 1 year time period. The third way of acquiring Indian citizenship, third one is by registration. Somebody can get the citizenship of India by registration. Mainly, the registered citizens, or by registering with the Indian authorities, mainly 3 categories of the people can get the citizenship of India. One is a person of Indian origin, and somebody, his grandfathers were Indians, they went to the US and took the citizenship of the US, and the grandson or the granddaughter, now they are the citizens of the US, but originally they are the people of India. Then the first category who can get the citizenship, normally who are getting the citizenship of India are person of Indian origin. Originally, their grandfathers were Indians, but presently they are the citizens of any other country. And second category of the people are a foreigner who got married to an Indian, either a foreign woman and who got married to an Indian man, or a foreign man who got married to an Indian woman. They will also get the citizenship of India by registering with the concerned authorities and subject to certain terms and conditions. Also, we will discuss the certain conditions and terms which is needed for getting the citizenship by registration after discussing the categories. And the third category of the people who will normally get the citizenship of India by registration is the children, minor children of these people. These minor children will get the citizenship automatically when their parents are getting. if a PIO or a person of Indian origin, he got the citizenship by registration, then their minor children who are below 18 years old will also get the citizenship automatically. And a person who got married to an Indian, when he is getting the citizenship, his children will also get the citizenship automatically. Then we can check. Next is, there are certain terms and conditions for these people before they get the citizenship. Then before applying for the citizenship of India by registration, this is for registration, we discuss three category of the people are normally getting the citizenship of India by registration. They are persons of Indian origin, second, a person who got married with an Indian, third one, their minor children. Now, what is the condition? Totally, before applying for the citizenship, they have to stay in India for 7 years total. They have to stay in India for 7 years. After staying in India for 7 years, they can apply for the citizenship of India by registration. That 7 years also no need to stay continuously, but 12 months, the last 1 year, they have to stay continuously in India. Then 12 months continuously. That means in the last 12 months, all the 365 days, or all, if somebody is applying for the citizenship of India on January 1, 2018, a person is applying for the citizenship of India by registration. Then the same person, January 1, 2018, he is submitting the application. Then in the last 12 months, he should be in India. That means from January 1, 2017, from January 1, 2017 till December 31st, 2017, he should be continuously in India. Even a single day, he should not go outside India. Then he has to stay. A person who is applying for the citizenship by registration, he has to stay completely 7 years. But the previous, just before submitting the application, the previous 12 months, he has to be continuously inside India without going anywhere outside India. Even for a single day, he cannot go outside India. Now, 7 years, out of the 7 years, we describe one year has finished. Now 6 years remains. 12 months he has to stay continuously, and the remaining 6 years he has to stay in India in the previous 8 years. Now 6 years he has to stay in India, but this 6 years no need to stay continuously, and in the previous 8 years before the 12 months, before this 1 year, and they can calculate. Imagine that he's applied for the citizenship on January 1, 2018. Then he has to stay in India from January 1, 2017 until December 31st, 2017. These days has to be continuously in India. Now, calculating from 2017, calculating 8 years back, that means from 2009 to 2017. In this span of 8 years, he has to be inside India for 6 years. That means 1 year or 2 years he can go to any other country and stay also. Then in a span of the 8 years preceding the 12 months, aggregate he has to be in India for 6 years. This is the condition. Total 7 years stay in India is needed. Out of the 7 years, 12 months should be continuously inside India, and the remaining 6 months in the preceding 8 years, aggregate he has to be in India for the 6 years. Then he can apply for the citizenship by registration. And if the question comes, how many years a person has to stay in India totally for getting the citizenship by registration, the answer is 7 years. Sometimes the question comes, how many months a person has to stay continuously in India without any intermediate disturbance of going outside for applying the citizenship, just before applying the citizenship for the country by registration. Then the answer is 12 months. Then the remaining 6 years he has to complete in the preceding 8 years time period. Next is by naturalization. After finishing the citizenship by registration, we are going to the fourth method of getting the Indian citizenship, that is by naturalization. Naturalization. Who will get by naturalization? There is no certain condition who will get by naturalization. Certain condition means certain requirements are there, how many time he has to stay in India. Any citizen of any foreign country, any person from any foreign country can apply for the citizenship in India by naturalization. But one condition, that person before submitting the application for the citizenship of India by naturalization, he has to stay in India for a total number of 12 years. Again, here also no need to stay the 12 years continuously. In between he has the freedom to go outside and visit his parents or family in the original country of the origin. For example, if a person from Thailand, he wants to get the citizenship of India by naturalization, then before submitting the application for the citizenship by naturalization, and he has to stay in India for a total period of 12 years. But here also, out of the total period of 12 years, 1 year or 12 months should be continuous. 12 months continuously he has to stay in India just before submitting the application. And in the same way, if a person is submitting application on January 1, 2018, he has to stay in India without going anywhere else from January 1, 2017 to December 31, 2017. 1 complete year, 12 months continuously he has to stay in India out of the 12 years. Now 11 years is remaining. Then the 11 years he must finish the stay of the 11 years in the preceding 14 years. And before January 1, 2017, in the 14 years before this, and calculating the 14 years, it will be from 2003 to 2017. Within the span of 2003 and 2017, in the span of 14 years between 2003 and 2017, he has to stay in India for 11 years. Then in the preceding 14 years aggregate, he has to stay in India for 11 years. For 3 years, whether it is continuously or in different time periods, he can go outside India. Then the condition for getting the citizenship of India by naturalization is that a person, before applying for that particular type of citizenship, he has to stay in India for 12 years complete, and out of these 12 years, 12 months or 1 year should be continuous just before submitting the application, and the remaining 11 years he has to complete the stay in the preceding 14 years. And that is the fourth method of getting the Indian citizenship. Then the fifth and last method of getting the citizenship of India as per the Citizenship Act 1955 is by incorporation of a territory. The fifth one, by incorporation of a territory. We already discussed in the last class that India is a sovereign country. Under Article 2, the Parliament of India has the authority. Article 2 talks about that the Parliament of India has the authority to give the admission to a new state. Then when the admission is given to a new state from outside India, or some state which was occupied by any other country, if we are admitting a new state into India, then automatically the people of that state would be considered, they will get the citizenship of India. And by incorporation of a territory, by adding a territory into the India, the people of that particular region will get the citizenship of India, as we discussed earlier. In 1965, we added Sikkim into India. Then in 1965, people of Sikkim got the citizenship of India automatically. Another one, Goa, and Goa was under the Portuguese control. Till 1962, Goa was under the Portuguese. Then Portuguese left Goa in 1962. Then in 1962, when Goa got the independence, we incorporated Goa into India. Citizens of Goa got the citizenship of India. And next is that Puducherry, and Puducherry was under the French administration, and Puducherry also the French administration when in 1960s, then the people of Puducherry also got the citizenship of India when they were incorporated into the territory of India later after the independence. Then by incorporation of a territory to India also, the people of that particular region would get the citizenship of the country. Then 5 methods are there for getting the citizenship of India by acquiring the citizenship of India for new persons. First one, by birth. We discussed 3 types of by birth, and second one by descent, and third one by registration, fourth one by naturalization, and the fifth one by incorporation of a territory into the territory of India. The next is overseas citizens of India, or simply we call them as OCI, overseas citizen of India. We already discussed that the Indian Constitution does not permit the double citizenship. One person cannot be citizen of India or any foreign country at the same time. And we already discussed that Article 9 talks about if a person voluntarily acquires the citizenship of any other country, he loses the citizenship of India. But when the time developed, the technology developed, people started migrating to different countries. Many Indian people who are highly intelligent and who are scientists, who are big business people, when they went to a foreign country, they liked it and started staying over there. Normally, when we go through the news of the Nobel Prize, most of the time we will find the American citizen, but the particular person got the Nobel Prize in physics. Then if you go through the news, in the last line you can see originally he was a person of Indian origin. Then because of this citizenship law, India lost many pride and prestiges. We are losing because once a person takes the citizenship of any other country, he loses the citizenship of the India. Then to sort out this problem, and there was a demand from the Indian citizens who took the citizenship in a foreign country to give them a additional citizenship of India. And to sort out this problem, in 2005 we introduced the Parliament of India by amending the Citizenship Act 1955. In 2005, the Parliament introduced a new category of the citizens. They are called as overseas citizen of India. A citizen of India who has taken the citizenship of any other country. Now, they have the half citizenship. They don't have the complete citizenship of India. Then the overseas citizen of India, we can check what privileges they have, what benefits they are getting by becoming the overseas citizens of India. One thing, they can stay in India. They does not need a visa to enter India. They can visit India without taking a visa. Second thing, they can stay in India for any longer time without any permission. If they have the OCI card or the overseas card, with that card they can stay in India for any longer time. And third one, they can purchase the property in India other than the agricultural property. Agricultural property they cannot purchase, the agricultural field or the tea gardens. These things they cannot purchase. Other than this, they can have the buildings, they can have the flats, and they can have the shares in the businesses in India. Any property other than the agricultural property can also be purchased by the OCIs. But they cannot vote in the election. They don't have the voting rights in the election, general election in India, whether it is a election to the parliament or state legislative assembly or into the decentralized Panchayati Raj institutions. They don't have the voting rights. Then OCIs, and we have given them a double citizenship almost equal to double citizenship. It is not a complete double citizenship because giving a double citizenship is against the Constitution of India. Then we have introduced from 2005 by Citizenship Act Amendment Act, we introduce a new category of the citizens called as the overseas citizens of India. That is a new category, and the launching of the overseas citizenship was done. The first overseas citizenship was officially launched by the government of India in 2006. In 2006, there was a Pravasi Bharatiya Divas. It is the meeting of the Indian expatriate workers in different countries. Every 2 years, there would be a meeting of the Indian migrants to different countries in any city in India. And in 2006, the Pravasi Bharatiya Divas was held in Hyderabad. Then in the Pravasi Bharatiya Divas held in Hyderabad, the OCI, the Overseas Citizenship of India, was launched by the government of India after amending the Citizenship Act 1955 in 2005. And that is all about the citizenship. What is the chance of having a double citizenship for an Indian citizen? It is not counted as double citizenship, but it is almost a half citizenship of India and a full citizenship of a foreign country. The next point is that Citizenship Amendment Bill 2016. In 2016, the government of India under Narendra Modi has brought a new amendment into the Citizenship Amendment Bill 2016. The aim of this bill is that there are many illegal migrants in India. Many illegal migrants are from Bangladesh. Many illegal migrants are there in India from Pakistan, and many illegal migrants are there from Afghanistan. Out of these migrants, many people are Muslims and non-Muslims are also there. The non-Muslims who are suffering from discrimination in Pakistan, Bangladesh and Afghanistan have also migrated, and many Muslims have also migrated, especially from Bangladesh. Many Muslims have migrated into India for the sake of the labor, job or any other needs. Then this bill aims to give the citizenship for the illegal migrants into India from Afghanistan, Pakistan and Bangladesh, but who are non-Muslims. It wants to give the citizenship for the illegal migrants who are Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from these particular three countries, Afghanistan, Bangladesh and Pakistan. The problem is that inside the parliament the discussion was that it discriminates. Article 14 of the Indian Constitution tells that no person, equality before law and equal protection by law. Everybody should be equal in front of the law. You cannot discriminate. The government of India cannot discriminate a person telling that he belongs to a particular religion according to the Constitution of India. The bill has not been passed by the parliament, but the government has presented the bill inside the parliament. The main provision, the first feature of the bill is that the bill wants to give the citizenship for illegal migrants. First thing is that they illegally came to India. The government wants to give them the citizenship. And these illegal migrants only from three countries. One is Pakistan, and the second country is Bangladesh, and the third country is Afghanistan. Then illegal migrants from these three countries now will get the membership, will the citizenship of India if this bill is passed by the Parliament, Lok Sabha and Rajya Sabha. Another condition for these illegal migrants are that they should belong to some particular religions. One thing, either they should be Hindus, Sikhs, Buddhist, Jains, Parsis or Christians. Only these religious groups who illegally migrated into India from these three countries will get the citizenship. Now, how they will get the citizenship? They will not get automatically, and normally a person who is a migrant from any other country who came to India from any other country, he can get the citizenship by naturalization. Naturalization means that he has to stay in India for 12 years, and for out of these 12 years he has to stay continuously for 12 months and 11 years in the preceding 14 years. That is the condition for getting the citizenship of India. But the government through this bill wants to relax these provisions for the illegal migrants who are Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from Afghanistan, Bangladesh and Pakistan. The relaxation is that these people will get the citizenship almost equal to the conditions, if they follow the conditions, which is equal to the conditions of getting citizenship by registration. That means now they have to stay in India only for 7 years. Out of these 7 years, 12 months should be continuously and the remaining 6 years in the preceding 8 years. If any illegal migrant who is non-Muslim from these countries, 3 countries, if he or she has resided in India for 7 years, out of the 7 years, 12 months continuously and the remaining 6 years in the preceding 8 years, then that person can get the citizenship of India as per the new amendment proposed by the government in the Parliament of India in the form of Citizenship Amendment Bill 2016. And one more clause is there under the Citizenship Amendment Bill 2016. The second most important clause is regarding the overseas citizens. The overseas citizens, now a problem is there. Overseas citizens, they can stay in India for any long time, but many overseas citizens coming into India, they violate the Indian law. But when they violate the Indian law, when they are going to be punished according to the Indian law, sometimes their original country will interfere. Or he is our citizen, then send him and hand over the person to us. He will go through the rules and regulations or the laws of our country because he is our citizen. Then we made a condition that if any OCI, under this bill, there is a condition that if any OCI, he violates a law after coming to India. If the OCI violates an Indian law when he stays in India, then he will automatically lose the OCI certificate. The OCI card will be taken back by the government. No more he will be an overseas citizen of India. He will be only the citizen of the country in which he has the original citizenship now. Then the second provision of the Citizenship Amendment Bill 2016 proposes that a person who is an OCI, if he violates any Indian law, the OCI card will be lost, or the OCI card, he will lose the OCI card. It will be taken back by the government of India. And thank you for watching, and next day we will come with another class on Indian polity.